Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law, Windshield Time. Today I want to talk a little bit about being a lawyer. I know that's an exciting subject. But you know, I saw a video here by another lawyer that I don't know personally. I've only, I've watched some of the stuff on YouTube. But talking about the question that always comes up, and I thought I'd address it. I'm a criminal defense lawyer. And you get the question, how can you defend guilty people? Or, how can you defend somebody accused of such a heinous crime? And there are a number of answers to that. I mean, you've got your quick answer that every lawyer gives going, everybody's entitled to a defense. Everybody's entitled to a lawyer, no matter what the charges are. The person is technically innocent when they're charged, okay, and they're innocent until they're proven guilty by a jury or they plead guilty, but they're innocent until there's a finding of guilt. Great, and that's correct. But there's a whole nother layer there that should be looked at, and that's the criminal defense attorney is the last safety valve. It's the last check the attorneys are. And I shouldn't say the last, because there's also the appellate attorneys who are phenomenal attorneys. I've done some appellate work, and I gotta say, I know some appellate attorneys that are just amazing. They're some of the smartest people I've ever met. But the criminal defense attorney is that check, one of the last checks on the power of government. We make sure that the government does everything right. We're not merely defending the client we have in front of us or alongside us at trial. We're defending all of society against unchecked government abuse of power. If you watch YouTube, you're gonna see all kinds of videos about cops of this and cops of that, and people that have attitude problems against law enforcement. The defense attorney is one of your last lines of defense there. We make sure that they do it right every time. And if they don't, we hold them to account. We don't let them get away with it. What does that mean? Now, it doesn't mean you're going to sue the police or we're going to file a 1983 suit every time you don't like the way a police officer talks to you. That's not realistic. What it does mean is if you are arrested and charged with a crime, I'm going to say burglary in this case, that we're going to make the state prove the elements of burglary. Okay? In Missouri, you have to be in the residence of another without permission or lawful right to be there for the purpose of committing a crime therein. Now, residence is also defined broadly as a building, and that's burglary in the second degree. Burglary in the first degree, there has to be another person who is not involved in the crime in the building. So you'll see people charged with burglary in the first degree for shoplifting from Walmart. Why? They were trespassed from Walmart previously, usually for stealing. The result of that is they're facing burglary in the first degree for shoplifting tube of toothpaste. So what is that? I mean, that's 5 to 15 years. Really? It's a little excessive, but it's one of the protections that they give our commercial folks, Walmart. So when we're defending that, the first thing we look at is, did you have a right or a license to be at that particular residence. Oh, for love of God, will you make your damn turn? Did you have a right or a license to be at that particular residence or in that particular building at that time? You know, were you there unlawfully or were you there lawfully? That's one of the first questions you have to look at. Then it's, did you enter that building for the purpose of committing a crime, or did the crime happen after you entered the building? And that's a much finer line. I mean, look, if that's your defense, you got a much tougher case. You know, did you go there for the purpose of committing a crime? Well, what's the crime? If it's domestic assault, if it's violence, you know, you honestly may not have gone in that building for the purpose of committing domestic assault. You may well have had every intention of going into that building for the purpose of making up or resolving an issue or just continuing on with your life. That's going to be a jury call, and that's a coin flip at best. I hate coin flips. So we have to make sure that the state proves every element of their case beyond a reasonable doubt. Now, that's a whole nother video. What the hell is a reasonable doubt? And I'm going to do one on those, on reasonable doubt. We'll probably do a studio video on reasonable doubt, because that one's going to take a bit to go into so that people understand. We have a definition, and you know, you're not supposed to go beyond that definition. But prosecutors try to drop reasonable doubt down. Defense attorneys try to pump it up. You know, it's the gold standard. So there's room to play in there a little bit if the judge lets you get away with it. But as far as how we protect society doing this, the reason that I say that we are protecting society is there is a likelihood that you could be stopped by a police officer anytime. You can be driving down the road and it could be your day to be pulled over. Maybe there's something going on. There could be an interstate manhunt for murder, and they're stopping every car. Okay. We can get into that stop and the illegality of that stop, and that's fine, and we will. But one of the things we're going to test is, did they stop you for a valid reason? Did they search your car for a valid reason? When they searched your car, they stopped you and they searched your car. Is that search a valid search? Did you consent? So if they conduct an illegal stop, then an illegal search, and they happen to find what they think is marijuana, they'll call it marijuana shake on the floor. In reality, it's probably just some leaves that were on the bottom of your shoes. But they'll find the marijuana shake or whatever it is that they claim is illegal. And then you're charged with it, you're arrested, and we have a court case to fight. So we have to look at all of that and see if they've done it right. And the recourse there is they don't get to use it. We file what's called a suppression motion, and we move to suppress that evidence based on the officer's illegal actions. The punishment, and it's not punishment for the officers, but it's intended so that they will not act inappropriately by disallowing the evidence. And suppression motions are powerful, powerful tools for defense attorneys. We could do something on that too. The essence of it is, yes, everybody's entitled to a defense. Everybody's entitled to have the evidence and force the state to prove each and every element of the offense beyond a reasonable doubt. And that's the state's job and responsibility. And if they can't prove it beyond a reasonable doubt, they have no business filing charges. Okay? That is something that just chaps my ass. Prosecutors filing charges they know they can't win. They know they can't make that case at trial. They do it, they cost the client money, the defendant money, they have to hire an attorney, and there's no recourse to the defendant. You want a ballot measure that will make a difference in this, and in bullshit prosecutions, you pass a ballot measure requiring the prosecutor's office to pay the defense cost for every case they dismiss. The flip side of that is they're not going to dismiss cases, which is going to hurt more defendants than it will. So that's not really a good thing, but there's no answer. That's the problem. Or, if the person's found not guilty, the prosecutor pays. It's a nice idea, but it'll never fly. It won't fly in practice either. So that's it. I mean, when it comes down to representing people, first, I never ask if somebody did it. I don't care. I don't want to know if you committed the offense with which you're charged. Okay? It's of no interest to me. All I care about is whether or not they can prove it. When I sit down and I talk to you, and I talk to somebody, we talk about what happened. I try to avoid that, what happened in a criminal defense case. I will ask them, before you say anything, I see a number of defenses in this kind of a case, or this kind of case typically has these defenses. Does one of these, sound more likely to you? And I'll explain the process. Look, if you sit there and you tell me, yeah, I absolutely did it. Man, I did it. I can't put you on the stand to testify to anything else. I can't do it. So, never tell your defense attorney you're guilty. And defense attorneys aren't going to ask. Most of the time, they're not going to know. They might think that you did it. They might believe you did it, but they're not going to know you did it. The evidence might tend to prove guilt. So, those are things, and those are fine hairs. That's like, I don't know what somebody did when I wasn't there. Did he or didn't he? I don't know. Did Bill Cosby do it? I don't know, man. I wasn't there. If somebody says he did it, he says he didn't, and you make them prove their case. That's it. That is how you defend people. You gotta make the state prove it, and that's my job. My job is to make the state show their work, not judge the people who are charged. And if they're found guilty, my job is to then try to mitigate the impacts of that sentence as best I can. We want to show the humanity. We want to show what may have gone into why this person committed an offense. We want to be able to show the judge and the jury what will prevent this from happening again. If there's a drug issue, we're getting the person into drug treatment. If there is an alcohol issue, we're going to get the person in alcohol treatment. We're going to do what we can do to mitigate the impacts of this and try to get the best outcome possible. Every defense attorney will do that. It's not something special. If they're not doing that, then I'd be worried. When it comes time for sentencing, the state's going to prepare in Missouri a sentencing assessment report. The defense attorney should too. You sit down and you go through your client's history and you prepare your own sentencing assessment report. And you present that to the court too. You want to show your client in the best light possible. Especially once they've been found guilty, even found guilty of a horrible offense. You need to show that there are reasons why they shouldn't have 25 years in prison. or they shouldn't face the death penalty, or there's a reason why the court should grant them the minimum sentence. Maybe that burglary in the first degree, 5 years, as opposed to 15 years. Whenever you're asking for something, you have to give a reason. Okay? It's something I've been teaching my kids since they were born. If they want to go to McDonald's, they need to give a reason. Why do you want to go to McDonald's? And that needs to be a reason I want to go to McDonald's, not they want to go to McDonald's. Okay? So my 6-year-old will come back from school and say, Daddy, it's getting late, and I know you're probably tired and you don't want to mess with cooking, so we should just stop at McDonald's because it's cheap and it's fast and we'll be able to have a good meal without a lot of work for you and Mommy. And swear to God, that's the kind of thing she says. So that's just straight negotiation. You've got to appeal to what the person wants. In this case, you're appealing to the judge. You're saying, look, judge, you should give my client 5 years instead of 15 because of X, Y, and Z. He's had some challenges with his upbringing. He's working on it. He has some drug issues. That's what we hope to do. So that is how you defend and why you can defend people in criminal defense cases, whether they may be guilty or not. And nobody is guilty until the court or the jury says they're guilty. Thanks for watching. Please hit like, subscribe, hit the alert button so you know when we post our next video, and you have a good day.